the defendant Erik Menendez with his counsel and the people are represented. Briefly, we've had a discussion relating to certain common issues that both this defendant and the co-defendant share, so that we will resolve those matters as best we can in relationship to this defendant to expedite, or in order to expedite, our brief hearing tomorrow with the co-defendant prior to argument. And so the counsel will be in a position to communicate with counsel for the co-defendant in relationship to the court's rulings here, which would, as to that co-defendant, at least be tentative rulings that would be formalized once we hear from counsel tomorrow morning. We're proceeding this way so that counsel for the co-defendant will have an opportunity to continue preparing their arguments for tomorrow morning. One of the matters that was being discussed yesterday with the co-defendant and addressed here, and counsel cited the court to certain cases dealing with the subject of involuntary manslaughter. The court has read those cases. People versus Welch at 137 Cal App 3rd, 834, and People versus Glenn at 229 Cal App 3rd, 1461. It's unclear from the opinion in People versus Welch as to whether that was a flannel type case or not. But in People versus Glenn, it currently was. What is the position of the prosecution in regards to involuntary manslaughter and the subject of implied malice, which are related subjects?
The people oppose the giving of an involuntary manslaughter instruction. Based on the cases cited by counsel, People versus Glenn and People versus Welch, those cases are clearly distinguishable from the facts in this case. In People versus Glenn, it appears that the appellate court focused on the defendant's testimony in that case, that he had repeatedly stated that he did not intend to kill the victim. They found that to be dispositive in that case, that the trial court should have given an involuntary manslaughter instruction. In this case, however, we have no evidence by either defendant that they, in their testimony, that they stated, or they did not state, that they intended to not to kill the victims in this case. In fact, defendant Erik Menendez testified that he intended to shoot with his shotgun anyone in the room. Later in his testimony, he testified that he knew after the first volley of shotgun blasts and after both defendants ran out of the house and after Erik Menendez approached his car, he testified that he knew his brother was going to kill their mother, and that, he stated, as he was supplying Lyle with the shotgun cartridge that Lyle was to return with and to fire at the mother as she lay moaning on the ground. So in fact, we have testimony from Erik Menendez that he knew his brother was going to kill the mother as he handed him that last cartridge, according to their version. There is no testimony, as there was in People versus Glenn, that the defendant did not intend to kill. In People versus Welch, I've taken a look at the copy provided by Ms. Morrissey. In that case, the defendant was in Compton playing pool with one Burnett. I'll call him B. B started an argument with the defendant, told the defendant that he was going to kick his ass. B threatened the defendant and rushed the defendant. The defendant reached for his gun and told B to stop. The defendant testified that he raised his gun and fired. The defendant testified that he did not point the gun. As the court in Welch indicated, the evidence was uncontradicted that B was the aggressor at all times, and the defendant testified that he did not point the gun. Those facts are very different from the facts of our case, and I think both Welch and Glenn are distinguishable. And I'd ask the court not give an involuntary manslaughter instruction.
Did the defense wish to be heard?
Yes, Your Honor. I think that the prosecution's characterization of Glenn is hinging upon the defendant's repeated testimony that he did not intend to kill is not entirely accurate. In fact, there was testimony from the defendant in Glenn that he did not intend to kill. That is true. However, the court also relied on other evidence that was introduced at trial which supported his statement that he did not intend to kill. And one of the cases that the Glenn court distinguished was Ibarra, which is cited IBARRA, which is cited at page 1466, in which there was a single piece of evidence supporting a lack of intent to kill, which was a statement by the defendant himself. So I think that the court has to look at the entirety of the evidence presented and not just at how many statements of intent to kill or lack of intent to kill appear from the defendant's testimony. With respect to the Welch case, that is kind of misleading because it's cited in the Glenn case. However, we actually supplied the court with Welch as authority for our request that special instruction number 9 be given, because what Welch does is indicate that a conviction for, in that case, involuntary manslaughter is appropriate if the jury finds that the force used in self-defense exceeded that which was reasonably necessary to repel an attack, and that was the point of special instruction number 9.
Yeah. I just wanted to be heard a little bit, Your Honor, on the
Yes.
notion of intent to kill.
Yes.
And as the court properly indicated, involuntary manslaughter does implicate the notion of implied malice. Our case, unlike Welch and unlike Glenn, has to do with an individual, the defendant in this case, in a state of mind totally unlike the men in bars syndrome. And what we spend a great deal of time and effort to do is to show that when you take a person who has been basically raised in in a purposefully fear-inducing atmosphere, whose basic behaviors have been shaped by fear, who was controlled by the bigger people in his life through fear, you wind up with a person who terrorizes much more easily than an average person. We aren't here talking about a person who's reacting from just an ordinary, misperception of fear, as did the defendants in Glenn and Welch, but someone who was thrown into a state of complete panic. And it's based on a life history of being made hypersensitive to fear, and based on the knowledge that he had been threatened with death many times over the course of his life if he did one particular thing, and he has now done that one particular thing, which was tell the secret. Now, the point of all that, and the nature of the defendant's testimony here, I think highlights that, is that he isn't acting in a rational or cognitive way at the time that he is firing these guns, his gun. He testifies that he is not pointing it in any particular direction, and the evidence at the crime scene verifies that. There are shots going through windows. It seemed to have missed anybody. He testifies he's not thinking that he's shooting his parents. He testifies that he isn't thinking at all, that he's in that state of panic where you're just reacting and acting and not thinking. And that people get into such a state was testified to by Dr. Burgess as a normal biological function, but that children of abusive situations have a hypersensitivity to fear and react in a more extreme way. Now, whether this evidence is believed or not believed isn't really the issue, but On the basis of that evidence, we believe that there is no, just as the court had indicated that people had desired an express malice instruction. Yes, there could have been expressed an intention to kill prior to these crimes. There is no evidence of that. But I think the people want to use what was discussed with Oziel later in order to support an express malice theory.
Well, express malice is demonstrated by what occurred, or could be demonstrated by what occurred.
And so is
You don't have
implied
to have a
malice.
declaration.
And so is implied malice demonstrated by what occurred. But actual intent to kill is a state of mind and not just a set of actions. And our position is that we have a right to have the jury consider whether the defendant actually had that state of mind and did intend to kill. And since the testimony did not establish that he did intend to kill expressly, and did not specifically establish with respect to Erik Menendez that he impliedly intended to kill, because there is no factual basis to find that he killed anybody, in fact, or that he fired his gun in such a way as to attempt to kill anybody. The physical evidence at this scene was left by the prosecution sufficiently mysterious, if you will, that it is impossible to determine who did what, except for those things that Lyle Menendez admitted he did, which was to be responsible for the 2 contact wounds, both of which were fatal, one to the mother and one to the father. That's all we know for sure that anybody did. And so based on that setup, this is unlike the defendant in Welch even, who's pointing a gun right at somebody's chest, knows he's doing it, sees he's doing it, yet says he didn't intend to kill. Whereas Erik Menendez testified he did not know where the gun was pointing, but for straight ahead of himself. He could not see what its impact was during the course of the firing, since everyone agrees there would have been a lot of smoke and it was basically a darkened room. And we think within the facts of this case, there is room for the jury to find that there was not an intent to kill.
All right, my inclination, as I indicated before, is not to give the involuntary manslaughter instructions. I don't see that this evidence that has been presented supports it. There is substantial evidence to support a verdict of involuntary manslaughter. If one looks at the definition of involuntary manslaughter, none of the statutory requirements exist for involuntary manslaughter. The reduction, if there is a reduction based on good faith but unreasonable belief in the necessity to defend, is a reduction from the level of murder to manslaughter by a rule of court eliminating malice and forethought if the jury so finds. And in this case, the court has been presented with no evidence, and the jury has been presented with no evidence showing that there is a basis for an instruction on involuntary manslaughter. This case is distinguishable from the case of People versus Glenn cited by the defense. I understand the argument presented by the defense further distinguishing this case from People versus Glenn, and the argument presented as to how this case is different. However, the evidence in this case does not support an involuntary manslaughter instruction, therefore it will not be given.
All right, I just want to clarify one thing. Is the court saying that the evidence must be substantial to support a verdict before?
No, just substantial enough for a jury to be instructed on the law of involuntary manslaughter. Clearly, I'm not weighing the evidence and deciding the issue, just deciding whether there's sufficient evidence for the instruction to be given. So the jury, if the instruction is to be given, then it would be for the jury to decide whether the allegation has been proved or not. But I'm ruling in this case that there is insufficient evidence for the jury to be instructed on the concept of involuntary manslaughter based on the evidence presented in the trial. The court has some other matters that are still in abeyance here, or held in abeyance, relating to special instructions primarily. And I gave you a list of those that were being held by the co-defendant. And I don't know if you've had a chance to relate them to yours and see
Yes,
if.
we have.
Yes,
Your 22 is our 17.
Okay, wait.
yeah.
Are they identical or?
Let's see. If they are, it's.
If they aren't.
Let's see, because I think yours is a little longer. Let's see.
No, they just have.
Oh, no, ours is shorter because we did not want to include the belief portion in it. 17 and 22 is the one that has to do with provocation and lying in wait and honor. We wanted to limit it to just provocation issues. They've included good faith belief issues. I think that, well, I won't argue against my own colleagues
No.
here. Just let them defend their creation.
All right, they've also submitted 8.81.15 modified.
Yes, Your Honor, and I believe that we also submitted that instruction this morning. That's our sixth set of additional jury instructions.
What is the people's position regarding that instruction?
Regarding 8.81.15,
As modified, yeah.
as modified, I would object to the last sentence on the second page, the entire second page. I think it's argumentative, it's confusing. If you take a look at paragraphs 3 and 4, I think it covers that issue.
Is that 10?
So I would object to that modification. I think that's the only modification they made, actually, is that
8.81.
that last sentence.
I'm not sure.
I don't know, we're trying to,
Well,
whose
try to-
problems are we resolving today?
Well, obviously, these would be things that involve you. I don't expect you to represent the interests of the co-defendant, but to the extent
This is
that they relate.
8.81.1. We have one like this, do we not?
Yes.
Is it identical?
The question I have is why is this instruction to be modified from the standard Calgic instruction when the case that you cite reviews the authority, and there's no suggestion that the instruction should be changed, although the case you dealt with was one of theory of first degree murder rather than special circumstance.
Well, I think Sager was first degree murder, but I think Edwards is a special circumstance.
Well, the one I looked at was Seja.
Yeah.
Okay, but the authority that's cited for this
Okay.
is Edwards.
I see now that Mr. Bird has cited Edwards.
Yeah,
which
Sager was cited for the provocation notion, Your Honor.
Yeah. So your feeling is that Edwards stands for the last paragraph relating to the murder done suddenly
Yeah, I think there
without a period of waiting.
is language in Edwards to that.
I think, Your Honor, the lying in wait instructions are, as the court knows from our pretrial litigation on the constitutionality of the lying in wait special circumstance, are extremely confusing.
Yeah.
And I think that given the facts of this case, where we are giving the jury a number of theories of murder and then this lying in wait special circumstance, it really is, it's necessary to explain to them the information that is contained in the last paragraph, which is basically if the murder is done suddenly without a period of waiting, watching, and concealment, the special circumstance of lying in wait is not present. Now, that's just simply true. And I think given the complexity of the instructions in this case and the specific problems with lying in wait that we have raised and litigated at length, and we won't repeat here, it makes sense to give this added this added paragraph which clarifies an important issue in the case.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
Well, actually, the instructions of theories of murder and homicide are rather streamlined, based to some extent on our previous discussion just this afternoon. There's really very limited theories of homicide. The people have opted to go for express malice and nothing else.
Correct.
So there's really nothing in dispute, and they've streamlined it by not requesting any theory of lying in wait. So there's no confusion there. And the language in 8.81.15 has within it, without the modification, the requirement of lying in wait, the watching and concealment. Waiting and watching for an opportune time to act, together with concealment by ambush or by some other secret design. It's all there, and I don't know why we need to add more language. It's just duplicative of what's already in the instruction. When you start modifying the standard instruction by adding things, there has to be some good reason for it. And I just don't see why this case would be different than any other lying in wait case.
Because what is every other lying in wait case these days?
That's true.
Anything short of sending a telegram before you shoot someone is lying in wait. I mean, if you read them all together.
I agree that the
And-
law of lying in wait has been
And
expanded. That's been
Seha, for
correct.
example, is one of the most unbelievable examples of that proposition. So I think that the point here is, I mean, because almost any kind of fact situation can be called lying in wait, I think what we're trying to do here is to focus this instruction without getting into the facts of our case to the issue as we claim it arose, which is that this was a quarrel. There was sudden action on the part of our clients. They immediately sprung into action without a period of waiting, watching, or concealing. They simply ran, got the guns, and went boom. And that's different. I mean, I'm sure you could think of some other way to try to highlight what was factually significant, or what is legally significant from the many components of lying in wait in some of the other cases, where, for example, people are with the people that they eventually kill for an hour or two before they make their move within the car, or whatever the facts are. But I think, given the fact that our theory here is sort of what was argued by the defense in Seha, but although rejected on appeal, which is that this was a quarrel, and it resulted in action on the part of the defendants without any period of waiting, constant movement and action resulting in the shooting, that we think we should be entitled to point out what is an obvious truth, that if the murder is done this way, it is not lying in wait.
Do the people dispute that this is a correct statement of the law? This last paragraph?
Frankly, I don't remember seeing that in the case itself, reading those particular words.
Is that in the case? That phrase?
In Edwards,
I don't have the page citation, so you have 54 Cal 3rd 822.
well, I don't know if that particular construct is in there, but that's clearly yeah, it is. In fact, it's a citation to, yeah, it is actually in there. Let me just- I think that it's in there. It's quoting with approval the instruction that was given in the trial at Edwards. And this is the instruction that was given in the trial, and this is quoted by approval by the Supreme Court. If the murder is done suddenly without a period of waiting watching and concealment, the special circumstance of lying in wait is not present. That was the trial court instruction that they're approving.
Okay, and what page was that?
It's 822, Your Honor. I'm sure.
That's at page 822?
Yeah, it's the very, it's the first line of the first full paragraph on that page.
Okay. All right, then I'll give that instruction then, 8.81.15 as modified. That's the same one for both defendants, is that right?
Yes,
That's correct, Your Honor. It's identical.
it's six. It's our sixth set of additional jury instructions.
Okay, as we discussed, if you would just put everything together.
Okay.
We shall.
So that I don't have to correlate 6 sets of,
I'm sorry for that, Your Honor.
that's
I'm
okay.
gonna check off
It's-
the co-counsel what's happening.
Things have been presented in stages here. Okay, that's one. Another one was your co-defendants number 10, which I indicated I would
Yes.
give modified.
Which is
Right.
our number 11, I believe.
I think they're identical. Didn't we modify it yesterday?
And that was modified,
Number 11 is in the second set of jury instructions.
But did we modify it to match this?
and let's see, Mr. Burt has submitted one,
No.
number 10, modified today.
I think, let's look at it because there were some modifications suggested yesterday.
Yeah.
And we will agree to take out,
All right, this
Okay.
conforms to the discussion we had yesterday.
Which one does?
Mr.
10?
Burt's 10, yeah.
I find the language, it may be reasoned that a person of such character would be more likely to act violently, a very artificial construct, Your Honor. And moreover, it doesn't go to the point that's in R11, which is such evidence may be sufficient by itself to raise an inference that Jose
No,
Mayer.
it's not. It's not sufficient, though. It's
Maybe it's
that's
all-
argumentative. The defect, as we discussed yesterday, I don't know if you were in the courtroom,
I
was that the defense has taken an instruction which relates to the defendant's character,
Right.
which if good character is introduced for the character trait at issue, that could be sufficient to raise a reasonable doubt. That's a far cry from what was in the proposed instruction relating to the victim's character.
So did the court, with respect to their special number 10,
It conforms to our discussion.
however, evidence such, was that a request to the court? Evidence of such character for violent or abusive behavior may be refuted or rebutted by contrary evidence?
No, that was in the original
I
submission
don't
by
think
the
there is any
defense.
contrary evidence.
I didn't ask for it. That was in what the Lyle Menendez lawyer said.
I would like, they want it, but we don't. So if we're settling their account today, obviously they want that in, and if that's acceptable to the people and to the court for the Lyle Menendez trial, good. But we'll be submitting 10 without that in it.
Well, then you would just want the first paragraph and a portion of the last paragraph.
Mhm.
yes.
Just
Which would have to be rephrased.
just for clarification, this is this defendant's special instruction number 11.
No,
No, we're looking at
We're
number
looking at
10
number
from
10.
Mr. Burt.
I don't have Mr.
Oh,
Burt's.
okay.
well, maybe you should come closer and we'll share them. This
It
is
was
what we're
submitted
trying to-
in conformity with my discussions yesterday with co-defendants counsel.
That's what they're submitting. And Mrs. Bozanich agreed to this form, Your Honor? or-
I don't recall if she did or not, but it was worked out. Well, why don't you then submit something different? But at this point,
Yeah, we will. If you
this
want-
instruction at this point conforms
Give it
with
to
the discussions that I had with counsel yesterday. I indicated I would give
Okay.
it in this fashion, so
Let me just check it off for their benefit then.
it will be given.
Okay. Now, I think the next one, Your Honor, was their 14 and R18. I think they're identical. Did we submit a new 18 today? Yes, we have a new 18 submitted today.
And I think this was one
This
that
is
the court
identical.
approved yesterday.
Right. We had modified this yesterday. Okay.
All right, that number 14 is going to be given. This is, again, the strike that the Lauman as 14.
And could the court also indicate that it will be given as Erik Menendez is 18?
Well, I'm not going to put numbers on them because you can perhaps,
I've got an 18 on it.
well, I'm just using the ones that Lauman submitted. I'm not even looking at yours at this point.
Okay, but I just want to know that something of ours has been resolved, so I'd like to just check off, given as modified and
Okay.
be done, that all.
Well, yours is going to be as is this one. So,
All right,
clearly any instruction that relates to the same issue for both defendants would be given as to both defendants when there was some.
okay, but sometimes we want things differently
Yeah.
than they do, and either way it's acceptable to the court, so. 18 would be given.
Okay.
I don't have your specials on this list.
No, we
I have it on this list.
I have it on the special.
Okay.
No, they're not on that list.
So this was your 18, you said?
This was our 18.
Yes, that was our 18,
It just,
which is in the most recent submission.
yeah. Okay.
Okay, I guess we just have to keep frying their fish here because there's no time. This is the fourth.
All right, the next one is the Lyle Menendez 13.
13.
Um,
Is that from their original package?
Yes, which we have. And this is an instruction that we have as basically our 8.42 modified. But let's just deal with theirs right now.
But, how can I deal with it when they haven't submitted a new version? Their 13 is there an 8.42 floating around somewhere in their
Well,
Case package.
I'm looking.
Do we have an 8.42? Where's your big package, Marcia?
Here's 8.42, I have it.
Their 13 was, I don't have the 13 on my copy. What was it? Oh, here it is.
Yeah, their 13 is a heat of passion,
Yeah.
prolonged provocation.
Marshall, which one is 8.42 modification?
Yeah, let's see if we can incorporate the district attorney in these discussions, obviously, so.
I don't have Lyle's, then. Which set?
The Lyle Menendez submitted either 13 or 15.
They've also submitted a 14, oh, wait, 14, that's right, 14 is given cleared, that's fine. So 13 and 15.
Okay, 15. And 13, both of them are argumentative and would not be given. Actually, the language is disapproved as praised here in a case I was just reading. I'll give you the citation. The portion that is appropriate is the portion that says with regard to well, looking at 15, a defendant may act in the heat of passion at the time of the killings as a result of a series of events which occur over a considerable period of time. That's already really included in the standard heat of passion instruction. And then the next sentence is argumentative, and there's a Supreme Court opinion that so states that it wouldn't be appropriate to give that.
What's the opinion?
I'll get it for you in a second.
Okay, because we did submit one.
We've submitted one like that also, that if it takes a substantial time to
Yeah, let me
get
get
cooking, it should
that.
take a substantial time to show
Let
out.
me get it for you right now because it basically says the first portion is okay, the latter portion is argument.
Hour 21.
Let me get that, and while I'm doing that, you can perhaps show that to Mr. Kuriyama so he knows what we're dealing with here.
Okay.
Okay.
If you can do that, I'll just be gone a second here and I'll bring that case up.
Okay. Lester, you should take a look at the conjunction with R21 and with
Yeah. He
R8.42.
says that it was this specific.
All right, back on the record, the case I was referring to is the case that's cited here in the authority for the instruction, People versus Wharton. The only difference is that the language was changed from that disapproved in Wharton from you must take such period into consideration to you may take such period into consideration.
What was the theory of Morton, though, that there is no comment?
Lengthening.
No, just the first portion was proper. A defendant may act in the heat of passion at the time of killings as a result of a series of events which occur over a considerable period of time. But then directing the jury's attention to that as a specific factor the jury should consider or may consider in dealing with the cooling period highlights one factor over others. I suppose we could come up with a list of all sorts of things the jury might want to consider in that determination. And the Supreme Court says there's no reason to highlight one over another.
I don't understand what they mean by one over another. If it's the product of a long history of provocation, I mean, isn't it just logically sound that it may take longer to cool off?
That's argument. That's where you'd argue. You know, why should the Supreme Court was saying, why does the court highlight a particular facet?
Because don't we, in fact, talk about, I mean, isn't the notion of the cooling period linked to the nature of the provocation anyway? I mean, it is a time construct just in the standard instruction where sufficient time has elapsed. So isn't it just logical to indicate that in determining what is a sufficient time for cooling period, you may consider the length of the provocation, the length of time over which the provocation extended. I mean, I think that just makes logical sense.
Well, it makes
The
logical sense.
duration of the cooling period is the time it would take the average or ordinarily reasonable person to have cooled such passion. And so the length of time that it took such passion to arise, one would think would be appropriate to call the jury's attention to.
Well, you are by saying a defendant may act in the heat of passion at the time of the killings as a result of a series of events which occur over a considerable period of time.
Well, all we're
You're doing
doing
that.
though is trying to show them that therefore in determining cooling period, you should consider the same notion.
Well, that's what the Supreme Court said you shouldn't do. Tell the jury you should consider something over something else. Although the instruction was worded a little differently in that it says must in the Wharton case versus may here. The
Well,
language in Wharton says by directing that the jury must take into account the long period of provocation in determining the effect of cooling off period. Defendant's proposed instruction improperly singled out one factor favorable to the defendant and improperly elevated it over other factors that the jury should also consider. this portion of the instruction was as objectionable as argumentative and properly refused.
Well, I'd like to take a look at the case again, just to see what the other factors are that existed in that case. I don't remember the facts well enough to know.
Well, okay. you
What
can do that.
other
I
provocatory factors
Yeah, I
may
don't
have been there?
recall what the specifics of that case were.
Right.
You can do that, but
Is that the
my
same
inclination
word?
is to,
Psychology.
if there is a request to give that instruction, to just include that first sentence, which was approved in Wharton.
What is it now? It's their special.
That's their 15.
Their 15. Oh,
Their
that's in the
15.
big tab. So you have to tell them they're making out from
Mhm. Now, we should tell them that they should modify it so as to delete the offensive or the
The second sentence.
The sentence.
You just have a one sentence instruction.
okay.
One of my favorite supplements is Counsel turmeric. Turmeric helps with healthy joints and inflammation support, and Counsel has the #1 doctor recommended form of turmeric. Counsel, the brand I trust.
that includes the language of co-defendant special 15. And I think what we'll do is take that language out of R 8.42 and make the part that the court's approved of just a separate special instruction.
Mayor, I would object to that. I think it should go hand in hand.
Yeah, it
with
should be in 8.42. It actually is already. 8.42 was modified because of Wharton.
Well, it's in the pocket part, but all that does is if there was provocation, whether of short or long duration. And what we want to talk about is a series of events occurring over a considerable period of time, which is somewhat different.
Yeah.
They're just talking about in other words, the provocation can be ongoing for 5 hours, but we're talking about 18 years.
Right. No, I think you're clearly entitled to the instruction, just a question of the format. If the people feel that it should be an 8.42, what I'll do is direct the people to prepare such, and then you can do it your way. Okay?
Well, are you directing the absent people to do it too? Because Mrs. Bazanich isn't here and she's going to need hers by tomorrow morning.
Well, she doesn't need it by tomorrow morning. I need it by Friday.
Okay. Well, okay, so long as the language is agreed upon, the form doesn't matter. It can be argued to the jury. What is it? Acceptable, Your Honor, the language of their 15, let me see it again. Not even get to ours.
Mr. Kuriyama has it.
Mr. Kuriyama, could I just see it for a minute so I can inform our co-counsel what it is the court's going to allow?
With
And what-
respect to special
I have
instruction number 15, Your Honor, in Lyle Menendez's package, it seems to me that you really can't equate the time it took for, as the counsel claims, for these people to be abused some 18 years.
Well, I'm not saying you are. I'm certainly not telling the jury anything about the length of time. It's just the explanation that heat of passion can result from events that occur over a period of time.
Yeah, so, I mean, the language that we have and that they have in their 15 and we have in our 8.42 is apparently language from Tompkins. A defendant may act in the heat of passion at the time of the killing as a result of a series of events which occur over a considerable period of time. That's all we're saying. And so the way we've submitted that is on our 8.42, and then we can take out our last two paragraphs, which is the language that was disallowed in Wharton. Right?
This is okay.
The burden is on the prosecution to establish beyond a reasonable doubt that the defendant did not act in the heat of passion. The court want that included in it?
No, that's in other instructions on
I'm sorry.
malice and
All right.
the burden on the prosecution regarding the elements of murder.
Okay.
I don't see any reason to have it there as well. All right, so that's 13 and 15.
And R 8.42.
Mm-hmm.
Then there was the
113.
number 19 submitted by co-defendant
Which one is yours?
19.
19's not in this packet. It's in the overview.
I
No,
don't
I'm a
know.
little uncomfortable, Your Honor, sort of settling these things.
No, we're not.
Right.
They're going to come
Right.
in, and
Right.
all we're asking you to do is to give them a little advance
Right.
notice so they know what is happening.
Your Honor, my notation was that number 19 was approved, and we submitted one that tracks their number 19 exactly as our special number 16,
Okay, I found it.
which is in the fifth set.
It's their 19.
Their 19 and our 16.
Yeah, that's People versus Horn.
Right,
I have that.
right.
All right, I think that basically completes these discussions on the combined instructions that deal with both. I indicated that my intention is to give 5.17 in its pristine form, as in CalJIC, as in pure, as prepared by the CalJIC committee, without modifications, rejecting the offers by the defense that have been
Now-
presented.
Let me just see for 1 second. Where does that leave us though with respect to Erik Menendez and the acting to avoid the
Forcible and-
commission of a forcible and atrocious?
Well, we'll deal with that one separately
Okay.
because I've ruled it doesn't relate to
Okay,
co-defendant, or I will rule tomorrow. I gave them an indication yesterday, and I renewed that today, and I'll tell them
Okay.
when they come in tomorrow.
all right, so the door's still open on that one?
Yeah, it's a separate
Even
issue in
just for that.
relationship to your client.
Okay, let me think, there were some other things,
Number 9.
1 second. I don't know where we are on consciousness of guilt, and if, something as general as two.
Well, we've resolved those as far as the co-defendant is concerned,
We
so,
haven't done.
But we haven't, and
yeah, we'll deal with that.
we'll get
My
stuck with
my
what.
feeling is that you folks can discuss it further and give me whatever combined effort you have, and then hopefully Friday we'll be able to devote time to it and finish it off.
Is there any chance that if you've ruled that it should be given in one form before, in their case, that we're going to get stuck with those rulings, even if we're more clever and have better?
Well, if you
words?
have some other argument that, well, some of these only relate to one and not the other.
Yeah, I'm not
so
talking about those. I'm not talking about the fact-driven ones. I'm talking about conceptually, as far as they're.
If there is something specific that you bring to my attention that they did not, sure.
Okay. All right, so then R210, statements made to physician, we'll deal with.
Yeah, that's one that,
What's happening with the Ozil one?
wait, hold on, you mentioned
2.23.1.
one. You mentioned something here, the
210?
statements to physicians.
Yeah.
Right.
I don't recall how that was resolved yesterday.
I don't know that it was. I wasn't here for all of it. I don't know that it came up.
I don't know that
yesterday.
it came up. I think
Yes, oh
that,
yeah, it did.
Okay.
And let's see if there was anything from the defense.
Well, we submitted a one because that was not,
Yeah, well, I just want to see if
Right.
Bert submitted one.
I think he did. It's in his later submission.
but not in the one today.
No, but not in the one today.
I'll check the transcript to see if that was resolved. My inclination is just to give the standard instruction in that regard, although there was some disputes about
Well,
whether it could be used to as prior consistent statements.
Right, because the testimony came after the clients had testified and their credibility was being attacked across the board. I mean, fabrication was the charge.
Well, but the motive to fabricate preceded their testimony and preceded the making of these statements.
Yes, Your Honor, I think that
That's the reason for the instruction in its original form, that a defendant wouldn't then be able to talk to a doctor and get the doctor on the witness stand and then use those statements for the truth of what was said. That's the whole idea of the instruction.
You were citing Ainsworth?
Yes, I was citing Ainsworth, Your Honor, which is 45 Cal 3rd 984, for the proposition that the court says that there may always have been present a motive to fabricate does not deprive a party of his right to show that another motive suggested by the evidence did not also affect his testimony. So I don't think you can look at it as simply as the prosecution would have the court look at it, which is they had a motive to fabricate from the time of the events on August 20th, 1989. The recent cases seem to suggest that the offering of a prior inconsistent statement necessarily is an implied charge that the witness has fabricated his testimony since the time the inconsistent statement was made. I think the prosecution has certainly offered inconsistent statements in this case. And I think that given the posture of the case and the changing attitude towards prior inconsistent statements in Ainsworth, that it's properly given.
All right, and what page and citation of Ainsworth?
I'm off the Cal Reporter. It is at, so let me find it, page 1014 to 1015
Of 45 Cal 3rd.
Yeah, 45 Cal 3rd.
All right, I'll look at that once more.
I think they're going well beyond the intent of that particular.
Okay, I'm not changing my decision at this point. I'll look at it based on their citation and before.
Are you going to leave it in the medical doctor form, or?
No, they were going to just say expert or something like that, since they didn't really have.
Okay, and we're submitting an instruction we want to be real clear on, Your Honor. In view of that and other instructions dealing with experts, our special
distinguish Oziel.
20. Yeah, because
Yes.
they kept saying they weren't having him testify as an expert witness, and
So we have an
We have
instruction
instruction
that
that-
says that.
even though he temporarily has a license, and I suppose forever will have the degree, he did not testify here as an expert. In fact, I was prohibited from asking him certain questions on the basis that it would involve his alleged expertise.
What I would do is maybe discuss that once more with counsel tomorrow morning, because I don't know if they brought that up as a concern as to whether or how they deal with Oziel if they use that phrase expert. But that was what we had discussed, using just the phrase expert.
Right. But in discussing that instruction and in other proposed instructions that we have where we talk about psychological experts, I want it real clear in the minds of the juries that we are certainly not referring to Oziel, and the people did not call him as an expert witness. And he didn't, in fact, really qualify as an expert.
Okay. Well, that's clear that that's what the people's position was.
Right.
All right, let me just double check the list here of things that might still be unresolved.
What about, or you want to hold 22, Seha, till tomorrow? That's the provocation lying in wait.
Yeah,
And you're going to hold, you've already ruled that they're not entitled to their 510. Is that what you're saying, Judge? This is the forcible and atrocious crime
yeah,
on the
no,
first?
yeah, they're just getting 517.
Okay, so I'm going to show that that's refused when I give them the rundown. And 517, their 517, you're refusing, you're going to give the,
Standard
Couch it.
517.
okay, I just want to go through their package today. 8.81.15 we're going to give, okay. Their special number,
It's antecedent.
this is antecedent, where are we on this? This is,
Yeah, we should probably resolve
We got it,
antecedent
yeah.
threats.
that's special number 3.
Oh, I have done that,
Have you?
put down, I thought. And then
Well, here's the
third
form that
submitted
he
something.
submitted today, Your Honor.
Yeah.
Yeah, what he did was he redid it just as we redone ours and tied it to the belief, determining whether the defendant acted in the honest or unreasonable belief.
You change altercation, confrontation.
Yeah, they have altercation.
That's number 3. They're number 3.
It's their 3 and it's our special number 1.
Second modification, which is in the 5th set.
Marcia, you're what's making me crazy. Ours is a little different because it also includes forcible and atrocious crime, but I'm just interested in the language that the court will approve so we can change ours.
The only question I had was the direction to the jury that you
Yes.
are to consider such. It seems like, again,
I'm not sure I think Pena used it. I think one of the cases actually used the mandatory
yeah,
penalty.
I don't know. Again, Pena was decided before Wright, People versus Wright, which was the California Supreme Court's change of direction in regards to these pinpoint instructions. What was that mumbling?
I prefer not to change right behind them in a second and a half, Judge. I mean, I sort of like the old rules.
Yeah.
You know, but then I'm old and I don't change easily.
I'm young, I like right.
It will, just as an aside, it will be interesting to see what the next lying in wait case is. It's getting too funny.
Anything.
Yeah.
Anything.
It seems to me that there's no reason why the court should be telling the jury that they must consider something.
The jury must take defendant's knowledge of uncontradicted antecedent threats into consideration in its determination of whether defendant acted in a manner in which a reasonable man would act. I mean, I think there is a reason to tell them that, which
Pena?
is you can't, well, this is Pena quoting Moore, quoting Torres. You know,
When they say
absent a
uncontradicted,
clear, let me just read for a second. Absent a clear instruction to consider defendant's knowledge of the uncontradicted antecedent threats made by Ambrosio to him and to others about him, we cannot be sure jurors did not construe instructions which were proffered as narrowing the scope of facts and circumstances which they were entitled to consider to only those perceived by any other reasonable man approached by Ambrosio while sitting in the bar at the Mexican Village restaurant. A defendant's knowledge of uncontradicted antecedent threats must therefore be taken into consideration in the determination of the reasonableness of a belief in the necessity of self-defense. And since the court isn't giving us self-defense but is giving us good faith belief, I think it also bears on honest belief. And so I think you do have to pinpoint that.
And Your Honor, in this case, this instruction does not tell the jury that they have to believe the threats. It said, if you believe.
Yeah, I understand that.
You must consider them, and I think they do have to consider them in evaluating good faith.
People wish to be heard?
In fact, Aris even says that.
No, Eris, the instruction given says may.
I believe it's improperly directive to the jury in violation of the dictates of right. And I would ask that the defense specify, they've presented 6 different versions of their specials. And they say it's number 1, but they've told me that they withdrew that one. So I'm not-
No.
Lester, it's package
5.
Package
It
5.
says 5th package, and then look at number 1. It's a
Number
redo.
1. We're trying to redo it in conformity with the rulings
I've
that we've
got
had previously.
Special number 1s, they're listed in 3
Okay,
different
it gets
forms.
confusing here because of that aspect of it. This was,
Let me find it.
I don't know what the,
It was,
what
this is
you
in the
have. I'm
most,
looking at the one submitted by Lyle Menendez's counsel today.
this is in the,
Number 3.
And it's right here.
we listed them all for you, Lester. You shouldn't be confused.
Now, there's a special number 1
Here it is.
listed in
Here it is. Here it is.
Their pleading's number 2, I believe.
Okay,
and now
let's
they've
just-
got a number 5.
Okay,
This
let's
is the
forget all the
second modification.
numbers and just look at it.
Okay.
Same number, modify it.
It's a very haphazard way to be presenting.
And we can do that. It'll be your time. All right, I'm just going to give this as it's been presented here by the Lyle Menendez Counsel.
Okay, now which one of those?
What else is it that you feel it has to be resolved here?
I think we resolved their 10 and their 14. 22 you're gonna deal with tomorrow. Now, that's all I know about that they submitted today. I don't know what's still pending from their earlier submissions.
We had gone through everything yesterday, other than
Okay.
these things. All right, as far as you then, I'll ask that you meet further to see how much you can agree to, and then give me a combined group of instructions so that I can throw everything else away or
Judge, did
set it aside and not look at it anymore.
okay, Judge, did our co-counsel submit an instruction, connecting a history of abuse with the good faith belief?
If they did, well, let me see. I would not give it. That's clearly an argumentative instruction. That's the type of thing that the lawyers have to argue to a jury, not the court instruct on. That's focusing on a piece of evidence that it would be inappropriate for an instruction.
Did,
I know you folks have submitted that.
yeah, we've submitted it.
They could very well have,
We've submitted it and we want a chance to argue without it having been argued out from under us by the other team, without our knowing that that's the only problem going second.
you'd have to look at their initial special instructions to see if
I
it
don't
was
think
there.
they did, actually. I think it's, we're the only ones who are doing that.
All right.
2.23.1, the believability of witness, the one with Dr. Ozeal, is
Yeah.
that being given?
That was modified
Yeah.
to
Just
delete
modified.
misdemeanor, say
Yes.
criminal conduct, I believe, or something like
So
that.
that's okay.
Okay, so we've got that in our form as modified.
What was the purpose for that deletion?
Because there was no.
You'd have to
we wouldn't
define, first of all, was it a misdemeanor or felony? You'd have to define what the misdemeanors were, and you could just,
That's why I would object to having that at all.
Yeah, but
well, there has been evidence introduced regarding criminal conduct, and it relates to his background.
I think the problem is if you delete the reference to misdemeanor, then they can assume that it is perhaps a felony, which makes it.
It was a felony.
yeah, right.
That,
It was a forgery.
That case that was rejected because of the statute of limitations, was that a felony?
That was a forgery. It's a felony.
I'm not so sure that it was.
Yeah, it was.
Well, the code section that was cited when it was discussed is a felony section. It might be a wobbler, and it
Yeah,
presented as
okay.
misdemeanor, but it was a potential felony.
See if you would have let him plead to the
That
wobble.
was my understanding. It was felony,
What about
misdemeanor,
2.2?
but if that's the case.
Sorry. What about 2.24? The evidence of character for dishonesty or untruthfulness may be considered. Was that given separately?
You're asking whether that was given for the co-defendant. Again, I don't want to get into, those things were all discussed with them a month ago.
I think that's exactly
And
what
then we went over the list again
that's-
with them yesterday. I don't want to
Okay.
go over it again.
Yeah, those are just,
I just wanted to
The
know what we still
standard
have to do.
2.24 was given with the modifications for their opposites.
Okay.
that's.
I don't want to consume any more time now on this. I want you back here Friday.
Right.
And we'll work out the timing of it as we see how the arguments go. If you would tell counsel to be promptly at 8:30 so that we can finish off any discussions
Okay,
regarding
I
these matters.
need to here.
You've marked it.
Column right here.
And we'll be in recess until tomorrow at 8:30.